arrive in it. And Mr. Floyd's book talks about all that. And then the post-1997 version talks about motivated by. That's what they changed. And one of the legislators has explained what the meaning of that purpose was. And it makes sense because all the case law tracks. Next slide. So I would also argue, as far as interpreting statutes, you have to look at the whole thing and you look at the intent. So if we just go back to Title 131, subsection A, it says all the interpretations of the statutes, you have to look diligently at the intention of the General Assembly, keeping in view at all times the old law, the evil, and the remedy. You're allowed to look at this. And needless to say, when the language of the statute is plain, susceptible to only one natural meaning, that's what you go with. And that was just came down by the Court of Appeals just a couple of months ago. And then they also talked about the prologue in a case that I think just came down about a week or so ago in White v. Stanley. We were just looking at, preambles and things of that nature, Your Honor. So it's not just the statute, but you can look at all these other things. Next slide, please. So Rico itself defines pecuniary value under 1614.5. It actually defines it. And the reason it's important is part of the penalty is you get 3 times a pecuniary gain, whether it's a civil case or a criminal case, as far as fines or anything that stuff goes. It's throughout the statute is what they talk about, pecuniary, pecuniary, pecuniary. Next slide. So when the government talks about talking demurs in this, 1614.2b and explaining it isn't a talking demur. We're not adding facts into this. The words mean what they say, and the author has explained to you, or the legislators explained to you what the point of that was and what the reason was for why they did it. And when the state says you can't rely on speaking demurs, that's not necessarily true. If you read Gibbons, Grubb, and Williams that I cited in the brief, there are exceptions to these things on a very limited scale. If you're not adding facts, but you're actually explaining what the actual statute is, those are listed in those cases. And so what the most important thing I'd ask the court to consider is there have been no prior challenges as to the pecuniary gain language as far as what it means in any Georgia case, because every case the state can cite, I can cite, or the court can find will have a financial or physical element in every single one of those RICO cases.
So in looking at those, let's assume you're right, and that's those previous cases all had those aspects and it's a requirement. What did the indictments look like in those cases? Did they actually spell it out to the level of detail that you're saying? Or is that just something, once all the evidence was in there, we had to have?
Some indictments spell it out. I mean, I don't know about the indictments throughout the course of the state because I can't look at it, but I know I was partners with Don Samuel when we went through the Dorsey case and all that. And I know what those indictments said. They were very thorough. They're 100-page document type of situations. Mr. Floyd was there on the Dorsey case as well. And, Mr. Floyd was the one that sort of motivated the prosecutors to go with the RICO thing. I mean, he is the sort of the godfather of the RICO and the criminal side.
But you're saying in the Dorsey case, unlike this indictment, it was more explicitly laid out that the scheme existed for the purpose of
the Dorsey case was
gain
based on unjust enrichment. He was using, there was about 50 financial overt acts that were in there. And when the state cites Dorsey, I take exception with it because they've sort of cherry picked some issues, but it dealt with all the fraud he was committing. He was getting money from other bonding companies to give them the licenses to have a bonding company. He was having his personal staff do personal work for him. There was just a ton of it. And once we get to the Dorsey case that I've cited in here, I'll explain out some of the more additional factors. But that was a pure financial case that had an ongoing multi-year conspiracy alleged within that case. And that goes sort of to the continuity. But what I'm trying to say to the court is the financial issues are obvious in all those indictments. I'm not saying that you stole $2 or $4, but those are obvious. For example, if we take it the most recent RICO case with the forced offenders, they've actually put in there, you money laundered X amount of money by taking these donations and paying it to buy glue or whatever it was. It was very specific in that indictment.
It's obvious just because of the nature of the charges that are alleged, or the
Right.
predicate acts or the overt acts or something like that, right?
Right, because there's no theft here. In Dorsey, there was theft. In the other case, there's theft or money laundering, specific financial issues. In our case, we have fraud and we have all those things. And if we look at the ECA, which the state just doesn't want to look at, is that even illegal? And so that all goes back to the ECA argument, but there's nothing financial, even a hint of it in this 90-some page indictment. And that's the point I'm trying to make when you compare it to every other case. You can sit here and read cases till the cows come home. Every single one of them will have some financial aspect in it that's plain and clear. The school teachers issue that Mr. Floyd worked on also had it because the teachers were being paid bonuses based on the results that they were getting, and there was other governmental monies coming in based on the results that the school are getting. It was obvious and it was alleged in there. I don't know how much detail, but there was no dispute about it. So I'd ask the court to look at the indictment in the four corners of it and say, where does this say there's anything financial? All right, next. So the state cited Shearson Lehman Brothers, Raw, REAUGH, and Phil-Dan Trucking. What they don't tell you when they're sort of saying, oh, the Manny's wrong about all this, those solely dealt with 1614(2)A issues. That truly arguably would be a preamble because it says we are trying to help fight organized crime and all that. And in some of those cases, they argued that you have to be an organized crime. You can't be a legitimate business in order to have a RICO. And they said that language doesn't mean anything, but that just explains why we did the RICO, that there's a societal problem. And that's why I cited to you the A in my second slide, Your Honor, that talks about it. So it's completely off base. The next set of cases, they talk about Rossello. They talk in that case, they were actually talking about the word interest. It really didn't have to do with the RICO stuff. So we can all cherry pick blinds, but we need to read the cases to actually understand what they mean. They were talking about interest, but more interestingly in Rossello, they actually said we're looking at legislative intent to figure out how we define interest as part of that case. Northwestern Bell was a private civil action. And basically they said, you don't need an organized crime syndicate, but you can go after legitimate businesses. It's not talking about the financial aspect. Schindler, it says economic motive not needed in RICO. And I put that in my brief out there, but we're not in the RICO. We're in the Georgia statute, which is more expansive, but it specifically says you have to have motivated by in order to do that. You can't get past 2 until to get to subsection 4. Next. So at the end of the state's response, they said, well, we do have financial gain and physical harm as far as that goes. And I guess it's a little silly because they're saying the financial gain is the perks of the presidency. Well, apparently the guy's a billionaire, so I'm not really sure what the perks mean. But again, there's also case law that talks about the attenuation as far as that goes. And I don't mean to be slight, but I can't even get within the 6 degrees of Kevin Bacon on this thing to say how the perks of the presidency are the reason. And it's not charged in the indictment. Nobody even says that that's the reason Donald Trump decided to do all this stuff all across the country was so he could make $400,000 a year and get free suits in a plane. And the same thing they talk about as a harm is to Ruby Freeman. Well, we discussed that. None of the co-defendants made any harm. If social media goes crazy and starts calling you these kinds of names, and almost every bully that ever existed could have that. You can't expand the conspiracy to such a point where people on social media, or if I can start attacking people, is Mr. Chesebro responsible for that? There is an attenuation line and the cases all talk about that. And so it's a little bit of a Hail Mary on the state's part to say, if you clearly find that there's a financial incentive that's necessary in these cases, then we've got the salary and the perks, which is ridiculous, or there's harm because social media made some kinds of threats to somebody. So I would ask the court not to consider that. Next slide, please. And so what I'll tell the court is there is no case law that's actually litigated one way or the other that the motivated by language is not a requirement, because every case has finances in it. Nobody's ever actually taken it up. There's been no prior challenge to the motivated language that I've come across. And RICO, based on its own definitions, is based on pecuniary gain. That's the issue. And so we've talked about novel applications of the law, and I think that's what we have here. And if you really want to get technical into the weeds, be it 5th or 14th Amendment and due process, you're supposed to have notice as to what your conduct can be wrong. Everything any normal person could do when they research this law, say you want to commit a crime, you'd see financial. All the RICO cases are against embezzlement, drug traffickers, gang issues, child traffickers, check fraud schemes, Medicaid fraud. That's where it all comes from. And there's no case that says otherwise. At some point, Your Honor, they're putting you under a lot of pressure to say, are you going to be the guy that dismisses the Trump indictment? There's all this press and everything out here, and this is why you get paid the big bucks. There's that old saying, let justice be done, though the heavens may fall. And that's sort of where we are. I mean, we can all sort of dance around it, and none of these press people or anybody in the public is ever going to say Scott McAfee did anything wrong. But if you say, you know what, the state is just wrong, they overdid it, we're all going to take a lot of heat. But that's the pressure that they're putting you on. They are flat out wrong on this. They're wrong on the ECA yesterday, and they're wrong on RICO because there's nothing they can cite to that says that there isn't a financial gain. There's just no case out there. You know that, I know that. So I'm asking you to dismiss this RICO as far as the financial aspects go, and then I'll come up and do the continuity. I try to separate it pretty well in my selection.
No, I appreciate that. And let's see if we can, as best we can, keep it siloed. But, and even if we follow you and say that there's no case directly on point. I don't know if I'm with you that we just can't read this and by itself determine that it isn't as restrictive as you're saying. I mean, I'm read it many times now, and it's saying it's the intent of the General Assembly of what it should apply to. It's not saying that it should only apply to that. And then that very last chapter about it being liberally construed. And I guess the bottom line, should a purpose clause ever be allowed to override the actual operative language? That's what we're looking at here, right?
Right. So essentially, we're de facto making law here because it's never come up in any case. And that's what I'm trying to ask the court to say. The tie should go to the runner. There's never been a case where somebody's challenged it because there's never been a case without that financial aspect already built into it. And so we can say it's silent, but does the silence penalize the defendant, or should it penalize the government for coming up with a novel theory as far as that goes? I know the court doesn't want to do the interlocutory, but this has to be resolved before we go through a trial because it doesn't exist out there. And that's my point to the court is, why do we get on the receiving end of these things when it's not clear? The lack of clarity doesn't hurt the defendant. That's what due process is for. And then lastly on this, we also had mentioned the enterprise element. I adopted Ray Smith's demurrer, so I'm not going to haggle it out. The court has it. But that's also there that Mr. Samuel talked about with regards to the enterprise element. I think you can read it just as well as I could elaborate.
I mean, but if there's anything you want to add to it, I mean, now.
No, I think it's pretty good. And,
Okay.
we cited the Boyle case and some other things out there. And again, in that issue is the connection between the enterprise and the acts, right? So in that case, the people that attacked different state capitals and battered the doors, are we responsible for all that? Are there millions of people that were protesting and things and causing grief responsible? So there's a whole issue as to when does this indictment actually break down? Because the case law says you don't need to have full knowledge of what the other conspirators are doing, but it also doesn't say zero knowledge. And so that's something that's more of a factual question. So I'm not, getting into that at this point, but I think the common sense application applies. And so I'll sit down, I'll respond back to Mr. Floyd, and then we can talk about, if you're all right with it, the continuity. I think I've broken it down pretty well in my slideshow.
Sure, but I think it would be Mr. Rafferty's turn.
Oh, I'm sorry. That's right.
Your Honor, I'm not going to repeat everything that Mr. Aurora said. Of course, I join his arguments. But I do think, the points that he's made about the importance of pecuniary gain and how that really is a critical component of a real RICO case is because of what we have here. The absence of any pecuniary gain or any requirement that there be pecuniary gain allows the government to charge a case in an unprecedented kind of way as we've seen here. Much of the conduct that's at issue in this indictment throughout is politically protected activity, folks that are doing different things that are lawful in order to challenge the results of the election. In fact, the actual crime that's alleged here to change the results of the election in favor of President Trump is not even a crime. But because there's no requirement that there be a pecuniary gain, as the government has alleged, they're allowed to charge all sorts of First Amendment protected activity politically in order to make a RICO case where there really isn't one. This is stretching a RICO statute, well beyond what it was ever intended to do. It's akin to what we saw in Arthur Anderson, Yates, Skilling, and all these other cases federally, where the government has tried to expand a statute well beyond what it was intended for. Now, with respect to the conduct here, if you look at some of the things that the government has tried to attribute to Ms. Powell, because her conduct here is very limited, but they have alleged throughout in their responses to both the general demurrer and the special demurrer that we filed that Ms. Powell is responsible for the overt acts committed by others. Look at some of those overt acts: petitioning state legislatures, petitioning party electors, petitioning Georgia state officials, petitioning federal officials, various acts under the Electoral College Act. All of these things have nothing to do with pecuniary gain, all of which are protected activity politically. People are taking lawful steps to challenge the results of an election to achieve a lawful purpose, which they are allowed to do. And people all over this country did that repeatedly. But the government, because they're trying to allege that there is no requirement, as Mr. Aurora said, that there be an element of pecuniary gain, they're charging folks for these kinds of things. And the number of folks that could be charged under the government's theory is countless. Anyone that had a conversation, anyone that did anything to challenge this election or challenge the concept that President Biden won could arguably be included in this indictment. I think Mr. Smith's demurrer has said this, that there could be literally thousands, millions of co-conspirators in this case under the government's theory. That can't possibly be. It can't possibly be, Your Honor. Constitutionally protected activities, as is alleged here, can't form the basis alone of being part of a Rico enterprise. And that's fundamentally the problem. Now, in our briefs, Your Honor, what we've tried to say is that the only way to put people on notice and give them due process under Georgia's Rico statute is through the intent of the legislature. That's the only way to put some boundaries or limits on the statute here. And as Mr. Aurora said, that limit is pecuniary gain and physical harm. And that just isn't present in this case at all. And so I join in the arguments of Mr. Aurora, Your Honor. I submit that this indictment is unprecedented. It is beyond what the statute was intended, and the count should be dismissed. This right here? Oh, this. Sorry. And I'll take any questions, Your Honor. If you had any, I'll turn it over to Mr. Floyd.
Let's hear from Mr. Floyd, and we'll see if we need to come back around.
Good afternoon, Your Honor. For the record, John Floyd, Special Assistant District Attorney. A number of things sort of got rolled into the 1614-2 argument, but I want to go straight to the core of that first. And I think it would be handy to have that up in front of us. So, Mr. Wooten, if you could please display the red line version of 1614-2. And Your Honor, part of the reason I want to do this is there's a lot in there. And it's worth taking a look at what we had before 1997 and what we had afterwards. First of all, as Your Honor pointed out, and absolutely correctly, this is not an operative provision of the statute. This is not a provision that defines an offense. That's 1614-4. The definitions are 1614-3. Others deal with sentencing, statute of limitations, et cetera. We don't really need to get into those. But the provision itself basically says, I'm not an operative provision of this statute. I'm not defining what the offense is. We begin with the fact that there are 3 cases that have been decided by the Georgia courts, and they're Shearson. I've never been sure how this one's pronounced, R-E-A-U-G-H. I've heard Ray and I've heard Rowe, but we have Shearson and Rowe, importantly, before 1614-2 was amended. And then we have Cotton afterwards. Cotton is a Georgia Supreme Court case. State v. Shearson, Lehman Brothers says as plain as it can be, the expression of legislative purpose is not an element of a violation of RICO. Roe follows it, addresses the argument that the scope of the statute is restricted by 1614-2, disposes of it saying this argument is without merit. Okay, that's as plain as it gets. Neither of these cases have ever been overruled. Cotton comes after the amendment, and an argument is made that a nexus should have been alleged between organized crime and that there was an adverse impact on the economy.
Wasn't there a point in the narrative there compelling or motivating the alteration in the preamble as well? I think there was a decision that the legislature was reacting to.
Yes, there was. And I'm going to get to that in just a minute. Because that relates to Mr. Clay's affidavit, former Senator Clay's affidavit. But the point is, when we talk about, you kept hearing there's there's no case, there's no case, there's no case. Well, 2 points. There are 3 cases that say, no, this doesn't restrict what a violation is. You look to 1614.4, and if there's a definition that matters, you look to the definitional section and how that word is used. That's number 1. So basically from our position, state 3, defense 0, right? Now you look to 1997, and I'll jump ahead because of the question you asked me. There is, and this is States Exhibit 1. This was not mentioned. If I can, I'll explain what I'm getting to the record. In 1997, April of 1997, then Senator Clay was interviewed by a student at Georgia State University. And this is something that Georgia State has done periodically, and they will have a student call someone who sponsored legislation and ask them about it. And this student did that. And so this document was generated by that student as a result of interviews with Senator Clay. And as you mentioned, this legislation came in response to a case called Sevchek versus Ingalls Markets. And as the article recognizes, Sevchek was contrary to the General Assembly's understanding of the statute and contrary to existing case law, because Sevchek required an economic motive and said you can't have a violation without it. Right? That's exactly the argument you just heard from Mr. Aurora, is that's the requirement today. In fact, the amendment was designed to make sure that wasn't the sole requirement, and that's exactly what the article says, and it is based on contemporaneous telephone interview with Senator Clay. And in fact, when Senator Clay explained his what he viewed it as the intent, he said that it is the General Assembly's intent that Georgia RICO actions may be brought not only for crimes with financial motives, but also for crimes involving non-financial ongoing criminal activities. And among the examples he gave, it's on page 2 in the 3rd paragraph under history, was political overthrow. That's what he said then. That's what went into this article. A bit of a backstory, Your Honor, is that the article goes through this. It explains that Senator Clay was approached by the Attorney General's office as a result of Sevchek. That's absolutely correct, right? And there's an interview with Michael Hobbs. Michael Hobbs was Michael Bauer's counsel. Mr. Hobbs' title was counsel of the Attorney General. At that time, I was a special assistant attorney general. I worked for Mr. Hobbs. I'm actually the person who wrote the first draft of that. Doesn't really matter one way or the other. I'm not going to try to tell you what I think the interpretation should be other than as an advocate, not as a witness. That's actually how it happened. Once upon a time, Sevchek came down. Bowers, Hobbs, and Floyd were sitting at a table eating a not very good chopped beef barbecue sandwich at Harold's. And the issue came up, it was recognized as a problem. And Senator Clay recognized it, and he wanted to fix it. But what he was trying to do is not what's being argued today. And the language of the statute shows that. When you look at the red line, one of the things you'll see is that it's paragraph 9 of Senator Clay's affidavit. He talks about how the intent was to restrict this to traditional organized crime activities. Now, I want to be very, very clear. I know Chuck Clay, and he is a good person, and I'm not suggesting in any way that he has tried to mislead this court. It was 26 years ago. And it does not appear, because he does not reference it, that he went back and refreshed his recollection from looking at this document. But when you look at the amendment, and you look at the second, I'm referring to the lines on the slide, you look at the second line, you will see that up to 1997, there was a reference to organization among certain criminal elements. You will also see, if you look down 8 lines, you'll see a reference to organized criminal elements. That's in the pre-existing version. The General Assembly took those out. The idea that this was intended to limit the scope of the statute to organized crime is exactly the opposite. It was taken out. And that is reflected in the article on page 3. As a result of the telephone interview contemporaneously with Senator Clay, the comment was it was to clarify the common misunderstanding that RICO only applies to organized crime and not to other types of ongoing criminal activities. It expanded the statute. It didn't narrow it. In addition, Your Honor, you'll see that there are other changes in the statute. If you look down, I believe it's 6 lines from the bottom, you'll see the language is added after a sentence that says it's not the intent that the statute apply only to isolated incidents of misdemeanor conduct or acts of civil disobedience. It then goes on, new language is added. It is the intent of the General Assembly, however, that this chapter apply to, and that continues, an interrelated pattern of criminal activity motivated by or the effect of which is pecuniary gain or economic or physical threat or injury. Very important, Your Honor. Look at the words "but only." Those were taken out. Those were words of restriction. Those words could have been read under the argument the defense is making today to mean it can't be X and it can only be Y. They took the word "only" out. And then in the next sentence, added the language that the statute be liberally construed. It previously said the statute must be construed to effectuate, to further that intent, okay? It changed it to it must be liberally construed. It's pretty hard to come in here and say a statute that must be liberally construed has to be construed narrowly, particularly when the language that would have said there can only be a single usage was taken out. The language was taken out. And if you're going to consider what Senator Clay says about intent, the thing you should be considering is what Senator Clay said in 1997 in April when the ink was barely dry on this amendment, not what is being said 26 and a half years later. Because through no fault of former Senator Clay's, it's just not accurate.
And so just to be clear, the Cotton case is also dealing with interpreting the prior iteration, right?
That is correct. It's decided 98, but well, Your Honor, I can't make the absolute representation, but it's a logical assumption because obviously it took the case a while to get to the Supreme Court.
Right.
So I think we fairly assume it was under the previous version.
Okay. But since this kind of trio of cases in the mid 90s, is it fair to say though, this hasn't come back up again?
I think it hasn't come back up that squarely. Well, the organized crime limitation issue that was reflected in, that's the specific point, and Mr. Aurora is reflecting that specific point, but I think he's missing the dispositive point. The organized crime limitation wouldn't come up because all the references to organized crime were removed to make sure it didn't. So that effort at restricting the statute was gone because they took the word organized out, all versions of it. And as the Georgia State article reflects, that was supposedly the intent of the General Assembly. Seems pretty clear that it was, given the specific words that they targeted. And this was a common argument in that time period. In the 80s and 90s, defendants commonly came in and said, this statute can apply. Same due process arguments you're hearing here. It has to have limitations. It obviously was only intended to apply to organized crime. The United States Supreme Court at least 5 different times has rejected efforts to impose limitations like that based on what Congress must have intended. And I believe it may actually have been in the Boyle case where Justice Alito said, we've long since given up on trying to figure out what Congress meant. We just read what they wrote. Fair enough. And they read the operative provisions because the federal RICO statute also has a preamble. It was part of the Organized Crime Control Act in 1970, Title IX specifically. ACCA, as it's commonly called, had its own preamble. And lo and behold, the argument was made both by criminal defendants and defendants in civil cases. This statute is only intended to be applied to organized crime. You actually still hear it in the media today.
Sure.
Supreme Court said, no, not right. We reject that. We are not going to use that preamble to limit the language that Congress picked when it specifically defined the offense.
And I think you laid that out in your brief, the comparisons to the federal preamble as well. And I know this I'm curious, just since it's raised here today and responding to it, Mr. Rafferty's comment, and it may get more into the void for vagueness issue, but would you then say that it is accurate to say that millions could fall under this statute, under this?
No,
theory
not
of
in
the
the
case?
least.
Why not?
No. Well, this has become a device. I've heard this in several of the arguments, which is, it's a floodgates argument, sky is falling argument. And the idea is that anybody who supported Donald Trump is subject to indictment under this case. That's absurd. That's absolutely ridiculous. The state has never said it. The indictment doesn't say it. We'd never do that. We now know something that we couldn't say before, which is the special grand jury looked at a whole bunch of additional people, argued, recommended that they be charged, and they were not. That's not what's
There's a difference
happening
though
here.
between discretion and the law allowing or disallowing something. So is there something in the law that prevents you from doing that, or is it just because you're
Good guys.
being nice about it?
Well, first of all, I would like to say we're being nice about it. I'd like to say we're being responsible about it. But I understand Your Honor's question. And the answer to your question is yes, because simply supporting a candidate is not committing a crime. Now, I think over there, Mr. Rafferty's heart is beginning to beat faster and faster as I say this. But the point is, we have to have some form of conduct. We have to have some form of intent. That's why we have overt act requirements. Okay. That's why we have boundaries on the statute. This is not you have a wrong belief. This is you did a wrong thing or you worked with other people to accomplish a wrong thing. And the idea that unlawfully changing the results of election can't be a crime, can't be a criminal objective is ludicrous. Okay, that's just gamesmanship. The point here, and by the way, there's a couple of specific points because we're sort of transitioning into constitutional, and I want to address any question you have there, but there's a couple of points I want to make sure that I make in response to what Mr. Aurora said before we fully transition to that. One is he referenced the alternative fine and he talked about pecuniary value, but what he didn't say is it's an alternative fine, and that's 1614(5)(d), and that sets it forth. The fine can just be a fine. It's got a cap on it. I believe it's $25,000 if I remember right. The alternative fine is pecuniary value gain. The court has the choice, but there's nothing that says there's no fine unless you obtain a pecuniary benefit. That's not what it says. Secondly, you heard, I lost count how many times, there is no case in Georgia that has not, no Rico case that has not involved pecuniary gain. That is not true. There have been Rico cases in Georgia against churches and they dealt with sexual molestation and they dealt with the concealment of that sexual molestation by employees and other persons affiliated with those church organizations. And there is no pecuniary gain there, none whatsoever. Are there sex crimes in there? Yes. Are there sexual batteries, aggravated assaults, etc.? Yes, there are. Is there pecuniary gain? No. Are those Ricos? Yes. One of them made it to the Supreme Court of Georgia. So that's just not right. We also are ignoring the exact language here because part of the argument is, in essence, what has been boiled down to, as presented by the defense, is there has to be pecuniary gain. Now, it says motive or effect, all right? The effect of Donald Trump becoming elected president is pecuniary gain. There's a salary. there are retirement benefits, there are expenses, there is healthcare, there is transportation. You have the most prestigious aircraft in the world to fly around it. You have the most prestigious house in the world to live in for 4 years. That is pecuniary gain. It's not diminished by the fact that he made a choice that he'd rather do that than do something else that might be more lucrative. That's not part of the analysis. And the defense can't inject it in there. There's nothing that supports that textually. Also, the question is, was the effect, and here we've got a conspiracy case, so was the potential effect physical threat or injury? Members of this conspiracy, defendants in this case, approached Ruby Freeman and tried to convince her that her life was at risk, that she was in danger, and that she needed their help. They sat across from her house and staked it out. They approached her through multiple ways. When Lee couldn't get through to her, they brought in Floyd. When Floyd couldn't get through to her, no relation, I should say, they brought in Cootie, and Cootie finally did. And it's Cootie who's on the recording basically saying, you're a problem for some people, and I may be able to hold this off, I'm paraphrasing, for about 24 hours, but that's all, okay? And what's the implication? If you give us the testimony you want, because you've already been vilified as this person who was involved in election fraud, you're the person Rudy Giuliani said was passing thumb drives back and forth like they were vials of cocaine or heroin, was his comment. So she's already been vilified. Yes, people are threatening her, but a member of this conspiracy, it's not limited to social media. A member of this conspiracy comes and says, you've got a real problem and you need our help. That's different, okay? And that is an effect of physical threat or injury. She was scared to death, absolutely scared to death. And so if this is a requirement, we meet it. We also talk about economic injury. This wasn't addressed by Mr. Aurora, but you have the whole routine in Coffee County. Members of this conspiracy, of this enterprise, go to Coffee County and they take things that aren't theirs. They copy ballots, they copy data, they copy other information, and they copy software that belongs to Dominion. So they're taking property of the state, and there is a charge of conspiracy to defraud the state, and they're taking property of a private entity that they don't pay for, that they don't own, and they don't have any right to. And all the arm waving in the world about somebody got an invitation to go there didn't give those people the right to take Dominion's property because it wasn't Coffee County's to give. They didn't own it. And just lest there be any doubt, in the computer fraud statute, information stored on computers is defined as property. So that's at least 3 separate ways that even if this was a requirement, we meet it. The due process argument was sort of tossed in at the end of Mr. Aurora's argument, and I'll touch on that briefly. It's in our briefs. We've put it in extensively. But this isn't going to be a news flash, I don't think, Your Honor. People have been challenging the constitutionality of RICO statute since federal RICO was enacted in 1970. It hasn't worked once under any constitutional theory, not once. In the late 80s, in a concurrence, I believe it was in Sedema, it may have been in HJ Inc., Justice Scalia made a passing observation. He kind of tossed it over his shoulder that maybe someday there'd be a vagueness challenge to the statute, and he thought maybe that would have some validity. That launched 1,000 ships. I mean, there had been a whole wave of early challenges. They were all unsuccessful. There was the post-Scalia comment concurrence wave. They were all unsuccessful. Collectively, there are hundreds of them. There's about 35 state statutes. They've all been challenged too. None of them have failed. And Georgia has been upheld against the vagueness challenge exactly that we've heard about here. Chancey versus State, I think it's 1985. It was the first major RICO case to go to the Georgia Supreme Court. This is old news. And when Chancey denied the vagueness challenge, it looked to a former Fifth Circuit case from 1976, one of the earliest federal RICO Circuit Court decisions in the United States versus Hawes. By 1991, the 11th Circuit was saying that vagueness challenges to federal RICO were completely lacking in merit. And in 1992, the 9th Circuit cataloged a number of challenges that had been made across the country in a case called United States versus Dishner, Dischner, 974 F. 2nd 1502 at 1508. And it said, everybody who's looked at this has rejected the argument. And I mentioned there are quite a few state statutes. And yes, guess what? The same challenges have been made there. And in our brief, we went through this, gave examples, Supreme Courts of Iowa, Hawaii, New Jersey, Idaho, Indiana, and Arizona, all rejected them. Intermediate appellate courts, New York, Wisconsin, Florida, Ohio, Oregon, Arizona, and New Mexico, all rejected. And so that's old ground. But not surprisingly, because lawyers are creative and they're diligent, they act on behalf of their clients, and that's fine. So now we have a sort of First Amendment modification to this that's come up. And the First Amendment nuance is that this is all petitioning activity. Well, no, it's not. And let's take a look at this. In Haley versus State, 289 Georgia 515, 528, 2011, Justice Namias did an extremely detailed deep dive into the Georgia false statements and writing statute, 16-1020, which is, as he noted, based on the federal counterpart, 18 U.S.C. 1001. And he looked at it and he said, basically the bottom line was the First Amendment affords no protection to lies that threaten to harm the government. In that case, you had lies that triggered or potentially triggered government activity. They actually did. It was somebody who put up a fake website saying that they had committed a murder and giving clues. Not surprisingly, that triggered a GBI investigation, dedication of a lot of resources to address it. And lo and behold, it functionally turned out to be a prank. The defendant said, well, sorry, I was kidding, but it's speech. No, it's not. We have a whole category of crimes in this country that involve some form of speech that are not protected by the First Amendment. You can't lie to the government. You can't lie to a police officer. You can't lie to a legislature. You can't forge a document. You can't create a false document and use it to induce government activity. You can't perjure yourself. All of those involve words or writings. None of those are protected by the First Amendment. This is not legitimate petitioning activity. These are people with a very specific goal who are willing to commit crimes to achieve it. That's different. And we haven't had a case that says this can't apply here. We're not the only case that's ever involved an election, by the way. It isn't. We keep hearing how unprecedented this is, and I'll explain, I think, later on in the argument. There are other Georgia cases that have involved elected officials and elections that have also involved RICO. But the point is, just simply saying there's some speech involved doesn't get it. There are plenty of RICO cases that have involved 16-1020 convictions. That was involved in Dorsey. Part of what Dorsey did was create false documents. And there were individuals there who gave false testimony and made false statements to law enforcement officials, not protected by the First Amendment. And the fact that there's an election involved doesn't change that. It's not a license. That's part of the problem here, is the assumption that if it's an election and you're disappointed enough in the outcome that the rules go out the window. It's not how it works. I want to make sure that I've addressed all the questions that you had, because I went back to talk a bit about First
and we'll
Amendment.
make sure, again, like I said, I think all these are going to bleed into each other, but for now, let's give Mr. Warren and Mr. Rafferty last word on their motion. on the legislative intent, and then we can start talking about continuity.
Okay, thank you, Your Honor.
I'm going to pull up the law review article and actually sort of explain it because it's something we looked at, and the fact that a law student interviewed Senator Clay, we've talked about that, but Mr. Floyd is incredibly bright and I've looked up to him for a number of years, but I couldn't on the law disagree with him more. We are not trying to narrow the scope of the Rico statute, and we're not saying it's unconstitutional. We're saying it's unconstitutional as applied because they're not following the rules. He talked about the prior version of 1614-2. I cited that to you as 6301-20. What you have to look at there, Judge, is the prior version, everybody agrees, you had an element of deriving financial gain needed to be there, and that changed to motivate is what I'm saying. But the original 1614-4 didn't have an element of deriving it. It was again in that quote unquote preamble part of it. That's what nobody seems to want to tell you. That's what made it the element as far as that goes. And so let's go through some of the cases that they talk about. Let's start with the law review article. What you need to see that I've highlighted is it says the act is intended to clarify the findings and intent of the General Assembly by stating that the provisions of the act apply to interrelated patterns of criminal activity motivated not only by pecuniary gain, but also by economic or physical threat or injury to others. That is what they said when this thing passed through. Go to the next page, please, Robert. This is on page 3 of the article. The General Assembly did not intend this sort of political dissent to be the basis of a RICO action. You can interpret it how you wish. And the last part that they didn't cite to you, to replace the previous language, the act provides that the Georgia RICO Act only applies to interrelated pattern of criminal activity motivated by or resulting in pecuniary gain or economic or physical threat or injury. It's always been this way. They're coming up with novel theories to indict people and pigeonhole it. Charge them with the substantive counts. The RICO doesn't apply. They cited to you as the Chauncey case. Couldn't be farther from the truth, Your Honor. Chauncey dealt with organized crime. And what they did on the void for vagueness in Chauncey was what is the definition of an enterprise or a pattern? Never about economic motive or physical harm as the requirements to the RICO statute. You're getting half the story from the government, and it hurts my heart to see this happen. The other thing with regards to MacArthur was, in MacArthur, that was where the church people were sued under a RICO statute because they were allowing molestation to happen. What they don't tell you is the RICO charges were dismissed against the church because you couldn't prove that the church knew that physical injury was taking place. It only stuck for the actual defendant that was tried in criminal cases. The church was excused from the RICO because you couldn't meet the physical harm element. There is no single case in the state of Georgia that doesn't talk about pecuniary gain, or in the alternative, as I said in my brief and put it on my slides, physical harm. One or the other is necessary. They want to talk about Dorsey. The appeal, if you read it, actually talks about the 50 financial overt acts that they were talking about. The appeal where they talk about continuity that's going to come up is under subsection E of that appeal, where they talk about the financial aspects of it. They're misquoting a lot of the cases to you, and I have to come in here and clean it up. The GSU law article says this doesn't apply to political overthrow. I dealt with that yesterday. If you look at Pennsylvania versus Nelson, they specifically said if it goes to where federal issue, being the election, in that case, it was Congress people. This is the president. It is exclusively a federal matter. That was 350 US 497, and that was back in 1956 because it was the only case we could find. Georgia has had other politicians that have been charged under the RICO statute. In fact, back in 1984, I think it was a labor commissioner or the McCullough or whatever his name was, but that was dealing again with financial issues because he was taking his boat and doing other insurance fraud type situations. There is Caldwell, I'm sorry. There's nothing that doesn't meet one of the two criteria, financial crimes or physical injury. And that's what bothers me with regards to MacArthur, because the church had their RICO cases kicked because they couldn't link it to the actual physical injury. There's no answer that the government has for it. They cite you Cheers and Lehman and they double down on it. And the Ball case and the Cotton case. Again, those talk about organized crime in subsection A of either the previous version of 1614.2 or the new version of 1614.2, they don't deal with economic or physical harm. I'm not arguing that the statute is unconstitutional. We're narrowing it. The law review article that you have, I have no objection to making that an exhibit, actually talks about it. And again, on two different places specifically says the new law is to allow for pecuniary gain and is a requirement. It says it twice, and that's what was on the interview with Senator Clay, and that's what he said here today. You can redline it all you want. I can go back and get the first draft if I want, but it's not going to change what the words on the paper are, Judge. And you will never find a case that doesn't allow for those two elements that I'm talking about, pecuniary and pecuniary or physical. It doesn't exist. This is something that needs to be decided by the Georgia Supreme Court because it's never gone up, ever. Continuity's never gone up either. But we'll deal with that in a second. So what I'm asking you is, they are putting you in the spot. Judge, do you have the dexterity or constitution or whatever you call it to dismiss this case? Because we're going to go wherever and get our accolades because we're going after Trump and you're going to be the bad guy in the black robe. This isn't right. This isn't that case. And nothing the government has cited to you can't be distinguished because it's just bald-faced wrong what they cited to you when you look at it. Everything's financial in those cases. Thank you.
It's kind of lends itself to the general demurrer that we filed on behalf of Ms. Powell. As Mr. Aurora said, our motion is not that the statute itself is unconstitutional, but instead is unconstitutional as applied. And I tried to make that clear in our reply that we filed just a few days ago, I think. And I think the court's question to Mr. Floyd is correct. Where would the limits be to those who might have tried to challenge the results of this election under the state's reading of the statute? Mr. Floyd tried to dance in response to that question, but he never really answered it, because the reality is the only limits are their discretion, which means this statute can't possibly allow for the criminalization of this kind of innocent conduct. The things that we talked about in our brief, Your Honor, things that are accused as overt acts, petitioning state legislatures, petitioning party electors, petitioning Georgia state officials, petitioning federal officials, all these different acts under the Electoral College Act. There were literally thousands, if not millions of people that did those very things without requiring some connection to pecuniary gain or harm. All of those people under Mr. Floyd's theory could potentially, by writing a letter, by doing anything, by having a conversation, they could arguably be accused of doing things that are in furtherance of some Rico conspiracy. And because they agreed with others who thought that that President Biden didn't win and that President Trump did, by saying that, by agreeing with them, by meeting with them, all of those millions of Americans would be in this indictment too. That can't possibly be what this statute is intended to criminalize, Your Honor. It is just unprecedented because it never was intended. The statute, the law, everything Mr. Aurora says makes clear that the statute was intended to criminalize certain types of behavior that had a connection to pecuniary gain or physical harm. And when you look at that law review article, Mr. Floyd talks about political overthrow. This was not political overthrow. These were actions that lawyers and other people took throughout the course of this conspiracy to try and overturn the election in a lawful way, pursuing all of the different options that were available to them, which included petitioning state legislatures, petitioning party electors, doing all the things under the Electoral College Act that Mr. Aurora covered yesterday, lawful approaches to trying to challenge the results of this election. And so, Your Honor, respectfully, this indictment is just beyond what the legislator ever intended. It cannot possibly be what was intended when the Rico statute was enacted, even when it was amended. It was designed to criminalize those that were pursuing something for pecuniary gain or for physical harm. That's not present here. These folks that were involved, including Ms. Powell, Ms. Chesebro, and everybody else that's been charged, all they were really trying to do was lawfully overturn the results of this election. That can't be a crime. Therefore, I submit count one should be dismissed.
All right. Does anybody need a break? All right. If not, let's forge ahead and talk about continuity.
Sure. Just a minute to get the slides up. You've got everything from early this morning, correct? All right, so we're back in the same uncharted land where essentially the government's asking you to legislate from the bench because there is no clarity as to what these terms mean. So let's go to the next slide, Robert. So as far as conspiracies goes, Your Honor, there's two conspiracies under the law. There's closed and ended, which could be a one sort of item with one overall arching goal that needs to be over a lengthy period of time based on 11th Circuit case law and the Supreme Court case law. Can't have a discrete goal, which I would argue is what we have here, but regardless, I don't want to get into the weeds. That's open and a closed ended, and then open ended is what we normally see, because unless you stop these people, the drug trafficking, the child stuff, everything is going to go on in perpetuity because they have to be stopped. And that's also discussed. And thought Trump versus Clinton, the case out of the Southern District of Florida, was kind of interesting, talking about the differences between a closed-ended one-item conspiracy with a discrete finding that you could run for president again versus what a regular conspiracy is. So let's just get to the meat of it under continuity. Yeah, that's fine. So we go to continuity, and sort of the one case is cited in the beginning for pre-1997 was Dover. And in that case, the government sort of says, oh, it doesn't, it says this and it says that. The actual facts are in the Court of Appeals in Dover, they discussed the three different federal approaches that Rico took. And Mr. Dover was arguing for an Eighth Circuit approach that said a single fraudulent scheme was insufficient to create a racketeering pattern, that you needed more. He didn't ask them to approach the continuity or the ongoing issues that we're going to talk about. And the case never addressed the continuity, and it was never taken up to the Georgia Supreme Court. It solely dealt with, is a single fraudulent scheme sufficient? We are not saying the two predicate acts aren't valid and all those kinds of things, but there has to be more than one scheme. And so again, we're looking at sort of the preamble under subsection A again. The next slide, please. So again, I want to emphasize, based on the state's reply that I think we got it Monday, and so I looked at it. So nobody's challenging that the two predicate acts themselves aren't sufficient. What we are talking about that they don't discuss is, even with the two acts, the statute itself requires an interrelatedness requirement to establish the pattern. So you can have two acts. Now, they can't be the same similar acts that basically are one thing going towards it. It's got to be something different. The case law is pretty clear, and we've sort of cited to that. So if we go on to some of the other state citations, every case that they cited, including Dorsey, which seems to be the big one, had lengthy conspiracies. I think that one had like 4+ years. They all had financial motives. And so Mr. Floyd can talk about, in Dorsey, they talked about the false documents and everything going through. But when you actually look at it and read the appeal itself, they're mostly arguing over the financial overt acts. And you can have a lot of those other things if it was motivated by pecuniary gain. Like, for example, in this case, Judge, they could have all this if they would have said that, oh, by the way, we have X, Y, and Z as pecuniary gain, which is what they did in Dorsey, which is sort of what everybody's hanging their hat on here. But also that they had lengthy conspiracies, which is the closed-ended or the open-ended, which I defined for the court earlier. The state cites interagency, and interagency didn't deal with the racketeering pattern as to continuity or a particular length of time. What interagency says, if you read it closely, is that a pattern doesn't require an uninterrupted connection between each predicate act. It doesn't talk about continuity. It talks about the relationship with the predicate acts as far as that goes. Next. Then we go to Overton, some of the other cases the state has cited. In Overton, which we also put in our brief, is it establishes that these aren't isolated incidents. It's a continuing pattern of criminal activity. In Overton, citing Dorsey, because you're talking about the length of time that it's going on. And underneath all this is the financial or the physical aspect that exists in everything. In fact, in the Dorsey opinion from the Supreme Court, they actually use the word ongoing pattern of theft of services. Ongoing pattern of theft of services as part of the holding as far as that goes. That's where I go back to subsection B of 1614(2), where you have to have the economic issue. If you look at, again, I'm saying it till I blue in the face, every case talks about the economic or the physical injury in this case. If you look at Dorsey's footnote 5, it specifically says we are not talking about anything else except for the financial issues, which is where the state quoted its continuity argument in their brief. This ruling obviates the need to address other enumerations of error, which similarly are premised on the assertion that the theft acts were improperly considered by the jury for RICO purposes. That's where the quote comes from. Ongoing pattern of theft of services were proven because they had 50 different predicate acts listed as far as what the financial aspects of Dorsey's case was over a multitude of years. So I'm not tattling or anything. I just want the court to look at the cases closely because we can all cherry pick what we want. I'm trying to, at least in our briefs, sort of give you the good, the bad, and the ugly. I've got a lot of but C's in there. They also talked about the means definition. The word means is used throughout the statute. It says such and such means this. So I'm not really sure how to address the means issue. But I would point out, if you read the indictment, they're saying it's under 1614C. There's a conspire or endeavor element. And so in some places it says initially it's a conspiracy, but are some of the others endeavors. But that's, again, ticky-tack issues, but it's just something to look at because the law isn't necessarily that clear. Go to the next slide. And so what I would say under continuity is the Supreme Court's case under Northwestern Bell still controls because it hasn't been overruled or changed. And the language in the RICO itself, from the law review articles and everything else, is based on stopping ongoing conduct. And there's no Georgia Supreme Court that's ever dealt with the continuity issue on point. I cited a handful of law review articles. I guess the most intelligent one I found was from Randall Eliason, a professor at George Washington, that sort of listed it all out as to what the continuity issues are from federal and what the Georgia says. And one of the things he pointed out that I didn't realize is the Northwestern Bell case came out the same week as Dover, when they sort of generically, as I said, didn't really address continuity, but sort of did. And Northwestern Bell has never really been dealt with head on in our state because those two cases came on the same week. So I don't know how one, the Court of Appeals could have, dealt with it. And that was one of the things that Eliason was talking about with regards to his findings on continuity.
So what about I think one of the main arguments we see in the response is that we need to distinguish between whether this is a conspiracy RICO under C or I don't know what you would call it, regular RICO under B. And so that a lot of these cases aren't going to answer these questions for us. So shouldn't we be looking solely at cases that are dealing more with conspiracy RICO?
So if you look at C, that's sort of the problem I have. I'm not really sure what the point of C is. C says you can conspire to do the substantive action of RICO under B in the 41 or 42 crimes that are listed. So in any conspiracy, you have to conspire to do a specific substantive act. They just don't have to prove that the act itself went all the way through. That's the point of a conspiracy, that we agreed to it and here are your two predicate crimes and all you go. So most of the crimes you're going to deal with B. It's very rare to see cases cited under C. I don't know how many you've sat through or prosecuted yourself. I don't think we did that many RICOs in the old days, but the C is either conspire or endeavor to do B with all the litany of issues. So it also lists a bunch of federal cases or federal crimes that can be part of our state RICO. So, and that was under 1614.3.5C under the definitions as far as I go. So I'm not really sure what it is that I'm supposed to be able to address. If you say conspiracy,
So
you
I mean,
still
I guess,
have to prove it.
but your position would be that C requires proof of C plus B, essentially, that C swallows B.
Count one. All the defendants with the offense of violation of the Georgia.
I mean, I recognize that C itself
They,
references B.
right. So I don't know what is it that you're conspiring to do? If you're doing a RICO conspiracy, you go from C into B because that's the RICO. The RICO statute is not a conspiracy statute. You can conspire to do RICO, you can conspire to do murder, you can conspire to do any substantive count. C itself doesn't say anything except I'm conspiring, a little bit of a lower standard, to do B. So I'm not sure when the indictment itself says we are saying everything is a conspiracy in this case, right? As you see through, we're conspiring to do B. So B is sort of what the elements are. And if you don't have the financial issues, you don't have the continuity, you're back. How can you conspire to do something that arguably doesn't exist under our law. And the fact that Your Honor has to struggle with it, it sort of kind of tells us as to the equal protection. Again, we're not saying it's vagueness. It's not this. The statute says what it says clearly. It's expressed in there. Next slide. And so the one thing I want the court to understand is every RICO case, you do it on a case-by-case basis. There is no pattern jury RICO charge. So we would have to come up with the elements and the explanation and all that stuff. It doesn't exist. You can go to Westlaw, you can go to your bench book. It's not there. And so Mr. Samuel and I had a nice and interesting discussion about it as to how, he's done it in the past and what happens. There's a few things in the pattern charges that talk about venue and where RICO is appropriate, but it's not like murder, 1, 2, 3, 4 that you've done it. So I go back to my due process analysis as far as why does the issue of the economic, the issue of the continuity, the issue of physical harm not control the day for the defendant? Why does the government in their discretion just get to bring it when there's been no other case in the history of Georgia jurisprudence that deals with it? There's not a case they can cite you that I can't distinguish and clarify, just like I did some of the other cases. Remember, they cited you, oh, there's no economic injury, or keep saying that. Well, that's what I'm focusing on, but I also said or physical, right? So where the kids were being molested at the church's RICO charges were dismissed. So let's go back to that. Only the person that did the molesting had to eat those charges as far as that goes. So I don't know what else I can tell you. This is about as clear/vague as can be, right? It's as clear as you can be in that you need these issues, you need continuity. There's been no Supreme Court decision. But at the same time, it's vague because, as Mr. Rafferty said, you can squeeze anybody into it. Mr. Floyd can say this is absurd, this is this, but what he tells you is that's their discretion. It may be absurd to do it because you remember in federal court, they said we would have indicted the Hawaii electors based on the same conduct as far as that goes. It's purely discretionary. There's nothing that stops them from doing this.
Okay. Mr. Rafferty, I think you joined this one.
I don't think I joined this one. I know what, oh, did I join this?
Yeah, I think you did.
Well, I would echo everything Mr. Aurora said. And, the one comment I'll make is what I made during my arguments about pecuniary gain that Mr. Aurora just said, which is there are no limits to the way this statute can be employed by the government absent the court intervening. They are going to charge and can charge in their discretion anyone under the theory that Mr. Floyd has advocated who had anything to do with efforts to overturn the results of the election, because they define it as unlawful. They think it's unlawful, notwithstanding the fact that many of the activities that are set forth in this indictment are truly legitimate ways to overturn the results of an election, all the things I said before. But if you supported that in the eyes of the government, the way they've defined the statute, that could potentially bring you into a RICO statute and a RICO case. It can't possibly be, Your Honor. The case should be dismissed.
All right, Mr. Floyd, why don't we jump right in there with talking about B and C and what you think the elements are.
Okay.
And really, I would wonder, why would anyone ever charge B if it seems so much easier to charge C?
Well, it's an interesting question, Your Honor. There is overlap potentially between these provisions. If you were to waste a perfectly good Saturday with Lexis or Westlaw, you could find cases in Georgia where A, B, and C have been charged, and a defendant's been convicted of all three. They did not merge because they have different elements. You could find B and C together with convictions on both. They don't merge. Dorsey was convicted of an A violation and a B violation. I think contrary to something that was said a little earlier, they did not merge. Supreme Court specifically rejected it. Overlap is not equivalence, in other words. And in some circumstances, you have a situation, could Dorsey have potentially been charged as conspiracy? Yeah. There were specific facts in that case, which included the fact that other people with whom he acted had already pled guilty, et cetera, before he was charged. So it didn't necessarily make sense in that case to charge them together. Doesn't mean they couldn't have been. But I think this is something we kind of harped on in our briefs. And I don't think it's just been said expressly in the argument that you just heard. So I want to touch on it. There is one thing that is crystal clear. It is not a requirement to prove a substantive violation as a prerequisite to proving a conspiracy. And I think that's what's being implied, but not stated out loud. And we've cited multiple cases on that. One of the United States Supreme Court cases the defendants have sort of shied away from is Salinas, which absolutely says that flat out and illustrates it beautifully. Salinas was a deputy sheriff in Hidalgo County, Texas. The sheriff was a guy named Marmolejo. Marmolejo was taking bribes to allow contraband to come into his jail, contact visits, etc. Marmolejo was charged conspiracy and substantive, federal RICO. So was Salinas. Salinas was acquitted of the substantive. He was convicted of the conspiracy. He went to the Supreme Court saying the jury should have been instructed that I had to engage in a pattern of racketeering activity. Okay, which is kind of goes to the threshold issue we're talking about right now. Okay, the Supreme Court said no, absolutely not, because Congress enacted this statute with a knowledge of the general body of pre-existing conspiracy law, which is absolutely clear that it is not a requirement to violate a conspiracy statute that you commit the underlying substantive crime or any substantive crime. Conspiracy punishes agreement. Conspiracy doesn't punish completed crimes. And so that distinction is crucial. And it's frankly the one that the defense is kind of ignoring and using to slip under the blanket here. Because continuity, you were told about closed-ended and open-ended. That was the reference. But you were told closed-ended conspiracy, open-ended conspiracy. That's not the language. It's open, closed-ended pattern, open-ended pattern. It's continuity, not conspiracy. And why is that important? Because continuity is a component of a pattern of racketeering activity. And when you look at 1614.4, you will see there are two substantive violations, A and B. Both of those specifically reference acting through a pattern of racketeering activity. C is the conspiracy violation. No reference to pattern of racketeering activity. No reference to racketeering activity at all. Instead, a reference to something totally different, an overt act, right? And Georgia law, and we've cited this at least in two different briefs, I know, and I apologize for the overlap, but as you observed at the beginning, some of these arguments come up again in various forms in multiple briefs, and so we've tried to give you a thorough response each time because we don't know which brief you'll read first. And we didn't want you to have to jump back and forth from brief to brief with cross references. So there is some duplication there, but Georgia law and federal law are perfectly aligned here. An overt act doesn't have to be a crime. So what you're hearing is the state has to prove continuity, which is an element, which is a component of a pattern of racketeering activity, which is not an element of what we charged. And so it's just wrong from the get-go. They're ignoring the text. And so I think candidly, the defense realizes this argument is defective. And so it kind of pivoted during the course of argument into an effort to re-inject the financial motive argument and to somehow say continuity means you have to have a financial motive. They don't have anything to do with each other. They're just two different concepts under the statute. And one of the things you didn't hear was the discussion, any discussion of the statutory difference. So your Honor's first obligation, you have to look at the text. Certainly if nobody's interpreted it, you're the first one who looks at the text. Here there's text and it's been interpreted. So let me explain what I mean by that. The definition of pattern of racketeering activity under Georgia RICO is different than the federal one, and advisedly so.
I think you're talking about the means and the require.
I am talking about means and requires, and I won't.
It's pretty well laid out.
Yeah.
In the briefing.
And you get that, all right? And so the context here is significant because we're getting all these constitutional arguments. So let me briefly address why that matters. Means versus requires might seem like a small distinction, but it's not. The United States Supreme Court first recognized that Congress had used requires instead of means and said pretty clearly, we'd be reaching a different result if it had been means. It's fair to think of federal RICO as sort of RICO 1.0. It's the first statute. It comes out of the gate in 1970. RICO states and territories have been enacting RICO statutes ever since. They've had the advantage of looking at the federal authority. They've had the advantage of time to adapt these statutes to their own needs and their own policies. Quite a few have used requires instead of means. Every state that has addressed the question has looked at that has said this precludes a continuity requirement. The word continuity is nowhere in the statute. There is nothing that compels it. It is extra textual. And so is there something that allows you to write that into the statute when the General Assembly didn't? Perhaps conceivably in some circumstance there would be, but when they use means, every court to look at that says that means, no pun intended, the definition is complete and self-contained, and there's no room to add any additional requirement. And we've cited all of those Supreme Court cases from sister states for you. They are entirely consistent with a case that you heard only the most passing reference to from Mr. Aurora, which was Dover versus State, which says you can have a pattern consisting of two predicate acts, part of the same scheme, without the added burden of showing that the defendant would continue the conduct or had been guilty of like conduct before the incidents charged as a RICO violation. Dover was decided within a few days of H.J. Inc. That's right. But the Dover court knew about it because it cited H.J. Inc. They weren't unaware of it. They took the time to reference it. They were right on top of this issue. Dover has been cited by subsequent Georgia courts over and over again for the premise that there is no requirement of continuity. It's been cited, and we cited these cases to you, by federal courts applying Georgia RICO, saying there's no requirement of continuity. See what the Georgia courts have done. Right? This is not some mysterious open question. This has been settled. And the idea that we've heard multiple references. The Georgia Supreme Court has to look at this. Well, the Georgia Court of Appeals has looked at it over and over again. And the implication that somehow those courts don't bind your honor is just plain wrong. I don't know if this is an effort to get an interlocutor. I'm not exactly sure what's going on there. But the fact of the matter is, this question has been settled. And there was a lot of discussion about Dorsey and trying to draw distinctions from Dorsey. But what you didn't hear was the quotation of the language in Dorsey that actually matters. Twice in that decision, and I remember it, I argued Dorsey. Twice in that decision, the court says two related acts constitute a pattern. You don't have to have anything more. And the argument was the wedge argument was some of these acts aren't acts of racketeering activity, or some of these acts weren't proven, and we don't know which ones the jury relied on, so we need to go back and do it again. And the Supreme Court said, no, there is more than adequate evidence of at least two. Two is all it takes. We don't care about anything else, and we're not looking at any of the rest of it. We don't have to go through this. That's the footnote I think Mr. Aurora reference, but we differ a little bit on how that's properly interpreted here. But the point is, continuity travels in federal law as part of pattern. In Georgia, the definition's different. It's not part of a pattern at all. But pattern is not part of the requirements for the state in a RICO conspiracy case. So that's it. It just, I mean, this is an argument, it fails at its inception because the difference in the text between C and A and B on the one hand. It then fails because of a difference in the Georgia text as opposed to the federal text, which led to the result in HJ Inc., where you get continuity. The idea that the Georgia courts are somehow lost, stumbling about in the fog because HJ Inc. hasn't been explored, the answer is simple. HJ Inc. recognized the difference between the statutes. Our statute's different. HJ Inc. doesn't apply. And that's what everybody has said ever since. And that's what the other states have said ever since. This is not difficult. This is not confusing. Sorry, I'm just checking my notes to make sure I've addressed everything that I think needs to be addressed. At one point, there was a reference to conspiracies as predicate acts. There's a fundamental difference. An act of racketeering activity can consist of a conspiracy. That would be an act. So you could have a pattern, for example, if you were trying to prove a substantive case, that would consist of 3 or 4 or 5 conspiracies. Suppose, I'll just hypothesize, they were because actually there are federal gang cases like this where there are multiple conspiracies to murder people. There's a plan to murder several people on the same day. Each of those conspiracies to commit murder was its own predicate act. They weren't independently a RICO violation. Together, they formed a pattern that supported the RICO violation. There's just a conceptual difference between the two things. And I think it's been a little bit blurred by the defense, I think inadvertently. But finally, the idea of constitutionality, because this kept coming up again in this argument, both Mr. Rafferty and Mr. Aurora referenced it. And this seems to now have become, you have to impose an economic motive requirement or the statute isn't constitutional. That is absolutely wrong. And the example is Scheidler, National Organization for Women v. Scheidler, which we have cited to you, in which the argument was made, RICO has to have a constitutional component. The Supreme Court rejected that. No one has ever held federal RICO unconstitutional ever since. There is not an economic motive requirement in federal RICO. There's not an economic motive requirement. I don't want to speak absolutely, but off the top of my head, I can't think of one in any other state or territory where that is a blanket requirement. And I've spent more years than I care about writing a really boring, thick book about state and territorial RICO statutes. So I can't say I have perfect memory of it, but I can't tell you of one off top of my head. There are some that require it for a specific type of predicate act, but a blanket requirement, no. None of those statutes have ever been held unconstitutional. So that just doesn't wash. It's not a constitutional imperative, and I won't repeat the earlier argument, but it's not a statutory imperative either. I hope I've covered everything, but if you have any questions, I'm glad to take a cut.
Mr. Rohr.
All right, Judge, I haven't written a thick book, but I used to play a nuclear physicist in a different life, so I'm going to try to hold myself to be somewhat intelligent, not disappoint my Georgia Tech folks from back in the 80s. Continuity is correct. The word isn't used in the statute. So we're trying to have it both ways, right? But economic harm and physical harm is, but let's not look at that as what they're going to say, but continuity is not in there. They will say federal crimes don't mention economic issues under federal RICO. So therefore states shouldn't have that. But federal mentions continuity, but it shouldn't apply to the state. It's always a circular argument with the state in this case because they've used their discretion inappropriately. They cite you to Salinas. Pull that up, please. And I will take you to the holding at the end of Salinas that I'd like the court to read to get an understanding of what that case dealt with. So this is where the B and the C, which is incredibly confusing, talks about well-established principles and contempt. Is there more to the other column, or is this where it starts, Robert? Go all the way down. Okay, let's go back up. So well-established principles and contemporary understanding demonstrate that although a conspirator must intend to further an endeavor, which if completed would satisfy all the elements of the substantive criminal offense, it suffices that he adopt the goal of furthering or facilitating the criminal endeavor and need not agree to undertake all of the acts necessary for the crime's completion. But you have to have a valid substantive underlying crime. If it's C, it's a conspiracy to do something that has to be valid. That's what Salinas is telling you out there. So again, we can cherry pick everything that we want, but if you read the whole cases, that's what I'm trying to talk to the court about, is it doesn't necessarily say that. It's vague. It's not there. So they talk about Dover. Dover's been cited 16 times. You have the citation. I had a whole slide on it. I didn't blow by it, and I've briefed the hell out of it as far as that goes. If your assistant or your law clerk or anybody goes and punches in Dover, hits citing references, 16 cases will come up, which are inherently all civil just about. If you then put in a search term of continuity under Dover, 0 comes up. It's never been resolved as far as that goes. And if you actually read the Dover case and read Professor Eliason's law review article, you will see that it was almost as a side issue. And that's why I told the court they were looking at 3 different analyses of Rico in that case. And they were talking about, is it one specific set of acts sufficient to do that? We are not challenging the 2 predicate acts. We're not challenging the pattern. We're not challenging any of it. We're challenging the fact that they do not allege, and this indictment does not prove financial or continuity, because there's nothing that says you have to, and there's nothing that says you don't have to. But all the cases, all of them that they can't contradict, Judge, went on for years and had one or the other as a critical, crucial element in there. And the old 1997 1644 didn't talk about the necessary financial crimes. It was in the preamble in that one too, just like it is now in 1614 too. And that was an element then. That's what they changed. That's what the law review article tells you. That's what the affidavit tells you. I don't know how much more circular I can be as far as that goes. So will you pull up the due process slide on the last slideshow? And I know we've talked about means, and I was a little confused as to government bringing that up in there, but I know this is silly because it's the definition of is. I'm sort of going all Clintonian, but the actual RICO statute doesn't define what means is. It just says this means that, or this means that. What does the word means mean that they're making such a big production out of? And if you look at a lot of other cases, it could be a lot of different things. And that's what I'm trying to explain to the court. There's no actual definition. They're reading it a certain way. We are allowed to read it a different way. What I would posture to the—
So your position would be that means is the equivalent of requires?
Yes, Your Honor. Why is that unreasonable versus what they're saying? I understand what the case law says, but they have a full definition section in RICO 1614.3. And nowhere do they actually define what means specifically means. We just suit it to suit our needs. The problem is none of the defense lawyers have ever challenged this because they've never had to. So if we go back to due process, what does it say? Scroll to the bottom, Robert, as far as the citations. Let me. It was Johnson versus Athens, Clark City, 272 Georgia, 384. It's in the slide before this, Your Honor, I cited it, but it basically talks about 4 different times in its holding that you have to have sufficient warning, fair notice, fair warning before you can be prosecuted for a crime. This has never been done before. And we shouldn't get to be the test case out there. And I'm sorry it puts you in a bad hat, and you're probably going to take a lot of heat if you do what the defense is asking you. But this can't be the standard. And so as an alternative, we've talked about potential appellate issues. You've said, no, that's fine. I understand. I respect that decision. But you can see how convoluted this is. If we can't agree, and I'm sure the courts like read a million cases, I'm sure all our heads are spinning. What are those 12 people going to figure out? when we go through this. And by the way, Judge, what are you going to charge them? There's no pattern as to elements because a lot of this stuff is elements. That's what they did in those other cases. Thank you.
I think this kind of bled over, as Mr. Floyd said, into both the general demurrer and special demurrer that we filed on behalf of Ms. Powell. And I think Mr. Aurora's point about due process is the underpinning of both of those motions that we filed on her behalf. The lack of notice. The conduct that's at issue in this indictment that are alleged as overt acts in furtherance of a RICO conspiracy are almost all legitimate acts to overturn an election. They are lawful conduct that the government is characterizing as unlawful, but that doesn't just make it so. And with respect to the conspiracy arguments that Mr. Floyd has made, I would say this. Even a conspiracy count requires somebody to have knowing and willful intent to do something that the law forbids. All of the underlying activity that is in here that is a part of this alleged conspiracy are lawful acts. So you can't be charged with a conspiracy when everything that's being done is designed to achieve a lawful objective. And so I'd rest on all the arguments that Mr. Aurora made, that we've made in our briefs with respect to both our general demurrer, our special demurrer, and suggest that the indictment should be dismissed.
Well, Mr. Rafferty, let's, if you're so inclined, since I think we would be finishing up with your other motions, why don't we have you stay up? And we, like I said, I think we might have already touched on void for vagueness, but if the other things I'd seen you raise and continuity, obviously, you'd raised some concerns about the enterprise as alleged here and the insufficient predicates. If you want to, again, any of these things and the other things you raised, I've got the briefs, we're working through them, but if there's anything you want to touch on or highlight or respond to, I think that's what this is most valuable.
I guess
this
what I would
time.
say on the enterprise, Your Honor, is this. The government has argued that the requirements for an enterprise are pretty limited. I would say, Your Honor, that the enterprise as charged in this case has stretched that concept beyond measure. You have a collection of folks from all over the country, it seems, who used a variety of different lawful means to pursue the lawful goal. That particular group of individuals can possibly be a RICO enterprise, in fact. I think that it sort of bleeds right back into what I said before. The extent to which these folks could be part of a RICO enterprise would essentially mean that anybody could be part of this RICO enterprise anywhere who did anything lawfully to try and overturn the results of this election. And so I'll rest on the briefs otherwise with respect to the enterprise, Your Honor, but I would just make that point.
We adopted that, the same thing in Ray Smith that I think did adopt.
Okay. Let me make sure I have that clear. Which one are you saying you adopted?
Ray Smith's brief.
Oh, no, I know.
About it, and so they adopted it too, and I think the enterprise.
All right.
I don't want to waive it because
Right.
I just want to waste your time since that brief was pretty.
No, I understand. Okay. I just want to make sure you adopted that one. Yeah, I got it. Okay. All right. Well, I've got the state's response to Mr. Rafferty's general and special demurrers. Again, I think obviously there's a lot of case law to get through and review, and we will be making our way through it. Is there anything else today that we think we need to address? Let me just go and, well, start with you, Mr. Rafferty. Sure.
I had one issue that I was hoping to bring up with the government and with the court and chambers, if you could.
Sure. Anything else on the record we need?
Not for the state, Your Honor. I take it the court doesn't have any further questions related to RICO, which perhaps by this time of the day is understandable. So no, nothing further for us.
Just for housekeeping purposes, the substantive demurrers that we filed, the court just going to rule on that.
I'm still working through them to decide whether we think we need a hearing on those. So I'd asked everyone to try and keep their more likely Tuesday, Wednesday afternoon open. We can also keep those open to talk questionnaires if we need to in person or anything else that may come up in the next couple of days. And so I'll keep you posted on that.
The last thing was just the jury strikes and the time. Will we deal with that next Tuesday or Wednesday?
Well, you've preserved the objection for the record right now. The inclination would be we can see where we get after the first day or two, and maybe I'll reconsider. And we can talk more about that as we get there. But I didn't see at this point the necessity or need to revisit that decision, especially since we're on the under the gun here to get this jury picked in about 10 or so business days. And I think, as we'd alluded to, you can.
Has Your Honor ruled on it? I missed it.
No, I haven't. Well, I haven't ruled on it. I just indicated what the plan was at the case management hearing. If you need a formal ruling,
May I address those?
Sure.
For the record, look, I understand, and I understand that we elected a speedy trial. With all due respect, Your Honor, we can't be punished for it. And I know that's not your intent. I know that. I think you've been an excellent judge. But I do feel like we are being punished for it, because speedy trial is a statutory right that defendants have in the state, and due process and the right to a fair and impartial jury are other rights that defendants have in the state. And I'm not trying to be flippant, Judge, but I almost feel like it's one of the situations that lawyers are told all the time by judges. You haven't said it. Well, Mr. Grubman, if you have a problem with it, you need to go talk to the legislature, not my job. I feel like that's what's happening here. There is definitely an argument to be made that the way the statutory and constitutional scheme is and how they interact, that if a defendant elects their speedy trial right, then it puts the court in a position where they have to speed up jury selection, therefore potentially compromising due process rights. And that's not a problem you created. But with all due respect, Your Honor, it's not a problem we created either by electing by electing speedy trial. Now, I said this in a footnote. I know Your Honor might have some feelings about footnotes. Other judges love footnotes, so I will take it out. But here's the thing. The case down the hall, the YSL Rico case, jury selection has been 9 months. Now, do I want to sit here for 9 months? No, not at all. But let's pay Chief Judge Glanville the respect he deserves, which is to say, it hasn't happened for 9 months because Chief Judge Glanville has had nothing better to do. I guarantee you, if we ask him why that case, the jury selection has lasted so long, he will tell you because it's lasted as long as necessary to ensure a fair and impartial jury. And amen to that. That's what we need here. And Your Honor, with all due respect, and you know this, Judge, this is in some ways the case of the century. This is in some ways the case of a millennium for the way it's been charged. And the bottom line is 4 minutes and 15 seconds per juror is not enough. These folks are going to come in. There's not going to be one person who hasn't heard of Donald Trump. And here's the thing about President Trump, and I don't say this in a good or a bad way, very neutral. There's no one who doesn't feel strongly about President Trump. You either love President Trump and you're willing to go into battle with him, or you strongly dislike him. I won't use the H word. And the state might stand up and say, well, but Donald Trump isn't at the table. But he is. We know he is. We know he is. We know, Your Honor, because Mr. Wade got up and said, we're presenting all 150 witnesses. By the way, that's now changed. The state sent us a witness list yesterday that had over 180 witnesses. So they seem to be going the wrong way here. And I don't understand why they could now call new witnesses after they completely blew through their deadline and they have made no showing of good faith of why they didn't know about this before. But putting that aside, 180 witnesses is not to prove a case against Sidney Powell or Ken Chesebro. It's to prove a case against the whole conspiracy. And Mr. Wade, I'll buy the transcript for you. Mr. Wade got up here and said numerous times, we have to prove the whole conspiracy that includes Donald Trump, and we need all these months to do it. And now we get 4 minutes and 15 seconds to ask a juror. And that's not fair. And I'm going to tell you, Your Honor, this case is going to come back if that happens. And I'm sorry, but it will, because that is not fair. And the fact that Mr. Chesebro and Ms. Powell elected to a speedy trial rights cannot be used as a reason why we're going to blow through too quickly. And there's just no justification, Your Honor, no justification for a judge down the hall to have sat through jury selection for 9 to 10 months and we get 4 minutes and 15 seconds per juror. That's unconstitutional. And that's all I'll say. Thank you.
So just a few thoughts in reaction. One, I don't think it can be so easily divided per juror. The intention would be that on my time, we're going to determine the hardships. And if a juror has to be excused simply because they can't financially make this work or for whatever reason. And so this panel of 14 may very well get whittled down to 8 or 9 by the time we're actually turning it over to you to questions and to seeing what's so fixed and definite. And you're going to have the benefit of a questionnaire that is extensive. And I think you're going to get a pretty good idea very quickly of which kind of juror you're going to want based on that questionnaire. And if in fact it's what you say that these opinions swing so wildly one way or another, there may not be that much nuance for you to explore. But the standard here is it may be unusual here in this courthouse, but I think it's pretty well charted federally. And I think there's been, depending on who's asking, desires to get more in the federal realm or away from it. But the bottom line is I've talked to the other federal judges, and it turns out an hour would be twice as long as the defendants would have gotten if it had gotten removed to Judge Jones. So there are competing values here, but the idea though, I don't think should be that one can invoke a speedy trial and then run out the clock. Which is, I don't think what you want to do, but it is something I think I have to be mindful of. And that what I'm saying is we'll see how it goes. If we do our first panel of 14, and based on that very first panel, we qualify 6, and then we're well ahead of schedule, and we can expand and contract as we need to. But at this point, the plan is that the first 14 that come in, it would be an hour per side. And same answer with the additional strikes.
Okay, and just one more thing about the additional strikes, just to clarify our argument. These are, I know it's brought together by Rico, and these guys are way smarter. The Godfather, I agree with that statement. I hope he's proven wrong in this case, but I'm not going to talk about Rico. But Judge, the fact of the matter is these conspiracies, these alleged conspiracies, they are different. And I'm not saying they can't be brought together legally under Rico. That's fine. That's why these smart folks got up and talked. But they are different. That deal, Sidney Powell deals with Coffee County. Ken Chesebro deals with the alternate elector slates. Now, the reason that's important is this. They're not contradicting defenses. I'm not saying that at all. But here's why they're not contradicting defenses, or whatever the word that the case law uses, is because they're totally separate. They can't be contradicting defenses. They're not the same defenses either.
Well, I'll recognize that y'all might have completely different ideas and juror profiles of who you think is your ideal juror. And I'll say that if we're going to grant an additional strike, it would just be 1, so that we could divide your strikes in half, and it'd be 5 and 5 apiece.
Okay.
But from that, I'm again, it's primarily motivated by the time constraints we're under.
Understood.
So we'll see where we get. If we have the ability to qualify an extra, what would that be? 3? No, actually 4. That's what we'll do.
Thank you.
All right. More. Or just were we ready to go off the record? Okay. Thank you all.
Thank you, Your Honor.